Good morning, everybody. My name is Jalen Carter. It is my pleasure to welcome you to our webinar, Trademarks and Branding for Startups. We've got a wonderful presenter for you all today, and she's excited to share her knowledge and expertise. I'm going to start off by reading her bio, then I'm going to pass things straight off to her so we can get started. Okay, so here we are. Meg Boulware is the founding partner of Boulware and Valoir, PLLC in Houston, Texas. Meg is a pioneer in the intellectual property law community on many fronts. She tried the first validity and infringement arbitration of a U.S. patent before the International Chamber of Commerce. She was the first woman president of the American Intellectual Property Law Association, received the first ever America's Women in Business Law Award for Best in Patent, and founded and fostered one of the earliest and most significant women-owned boutique law firms in the nation. Meg has litigated over 100 patent and trademark cases in forums and venues across the United States and has prosecuted a significant number of technically and commercially important patents through issuance, including pioneering patents on cloning. She advises companies on their international trademark strategy and is active in the International Trademark Association. In addition to her legal career, Meg serves as the trustee of the Houston Grand Opera and board member of the University of Houston Moores School of Music, where she serves as chair of the Opera Production Council. She is also a board member in the Rutherford B. Yates Museum and Freedman Towns Museums, devoted to preserving historic homes in Houston, originally built by freed enslaved people after the Civil War. Meg, thank you so much for joining us here this morning, and we are excited to hear what you have for us.
Thank you, Jalen, and thank you for inviting me here. Our firm enjoys a nice relationship with Tulane, and we have represented some of your wonderful entrepreneurial inventors. And so I started my career primarily in the patent area, but patent and trademarks are in the same government agency, and I got more and more interested and enjoyed the trademark work a little bit more. So I'm doing a lot more trademark work now. So I will start out with our first slide on branding for startups, but this is for existing companies as well. It's interesting. There's a lot of, as there is an intellectual property law that I'm sure you have learned through this wonderful series of seminars, a lot of mythology out there on intellectual property rights. And I wanted to talk about branding to start with. And also, Jalen, I'll ask you if there are any questions that come up in the chat. If you could bring those up for me, that would be great. And
sure thing.
Yeah, and I look forward to sharing some insights with you. First of all, I'd like to go over some brand qualities. This is not as much of a legal discussion as it is of branding and what to keep top of mind with your brand selection and brand use. First of all, finding a protectable mark that is to convey whatever your new company's goods and services are going to offer to the customer, your target customers. This is something that some people are very good at and very creative at, picking a brand that's going to convey to the customer what their goods and services are all about. And sometimes it's a bit of a challenge. Also, I'm going to discuss trademark registration. Trademark registration is very important to protect your core brand. And also, obtaining a trademark registration, as I'll show in some future slides, is also going to help you protect some of your other intellectual property. Also, a good brand is very important for social media, which is becoming very important, as we all know, in getting your goods and services identity out to the market. Also, it's good to have a recognizable brand for analysts who are going to be looking at the marketplace, who are going to be looking at companies to invest in. And then I'm also, hopefully I'll get to the end and talk about some non-traditional branding to build up your core IP that you can do in a manner that's less expensive than, for instance, patents. First of all, you really need to know who your customer is going to be. This is something that I see from time to time, that there's not initially, once you've got your concept and you're rolling on trying to form a company, is going to who's going to be your potential customer to find out what they see as the value of the product. Because what they see as the value of the product is something you need to see if you can incorporate into your branding. And it doesn't have to be a real complicated consumer survey. If your product is going to be a medical device, for instance, it's great to go to find some of those surgeons and nurses that are working in that area and ask them about what they're looking for. Is your concept something that they're interested in? And if so, why? And another item at the outset, very often the engineers and the creators and the scientists, which I was one before I became a lawyer, we get very focused on the product development. And very often I'll find that the engineers or the product creator, the entrepreneurs that are coming up with a particular product, they conjure up a name for the product, a brand, a trademark that they want to use because it means something to them. But the customers own the brand. You really want the brand to resonate with the customers. And I don't think enough outward focus often is incorporated in a brand creation. So your customers do create your marketing. Now, your brand designates your source or origin of your products. And there are a lot of good, well-known brands out there. And while you're picking your brand, it's also good to have it sync with a positioning and branding strategy. This is not a legal slide at all, but this is incorporating your brand into your elevator pitch. And I like this slide because all of the entrepreneurs, you need to have like your one paragraph elevator pitch with your brand included to have at the tip of your tongue. So when people ask you what you're doing or, what your focus is, you can kind of come back to them with a very well thought out branding strategy and pitch. And I think this makes a lot of sense because if you talk about your product or services and why it's going to be appealing to your customer target, because, and this is your value proposition, because it's going to be safer or more efficient or less expensive or whatever it is. And then you compare it to your competitive frame which is your competition out there that you want to beat, right? And then the reason for your customer to believe it, and that is because you've got excellent testing to back up your results. that there is a real need for this type of product. So having your brand selection woven in with your positioning strategy is very important. So I will say some of these slides are directed to the oil and gas market. I don't know if we have any oil and gas entrepreneurs out there, but I'm going to be using them as a little bit of a example. So often the branding strategy is it's often there are two different types of brands to pick that are the best. There is a suggestive brand, which is going to not describe your mark in a descriptive or a generic way, but what's called a suggestive way. And the line between suggestive and descriptive, very, very, very difficult. But a suggestive mark would be such as Productive Drilling, which was a registered mark for software to help with software. I'm getting some feedback. Are you hearing it, Jalen? No.
We're not hearing a ton of feedback.
Okay, good. For some reason I was getting, so this was for a software for assisting in visualization in oil and gas drilling. And it was not deemed descriptive. The trademark office in the US and other jurisdictions will not allow a descriptive mark. They'll allow what is a suggestive mark. And then sometimes you'll have descriptive words that the company, for one reason or another, has just settled on. They want to use descriptive words as their brand. If you have descriptive words, you can't use them as a brand, particularly if they're going to be really generic words like, again, this is from the oil and gas industry, wireline conveyance system, which would be something that's going to take some type of tool down into the well hole. But acronyms like WCS will be protectable, and you can, it's like international business machines. IBM is protectable. And the next thing is there's no trademark protection for highly descriptive or generic marks. I chose 3D drilling kit for software that displays three-dimensional drilling data. So we've got the tension, often mark selection to convey function to end users that include a suggestive feature, and striking the balance between the protection you can receive and the market identification is super important. The other types of marks that are often quite good are ones that are totally fanciful, that really don't have, that are totally imaginative, don't really describe your products, but maybe will stick in the mind of your consumer. And I'm going to talk about one of those in a few more slides of creative marks. But these are some marks that have been used in the oil and gas industry that were all, I would say, suggestive but protectable. So you've come up with your brand and you want to find out, can I use it? First of all, an internet search, which is what most people will do, is a good place to start. You need to see if what you have chosen is terms that you're finding all over the internet that are used in the industry generically or descriptive, then you need to stay away from those. They're just not going to be protectable. When you find exclusive use by a third party, that's a red flag. That probably means you've got somebody who's got a registration, particularly if you see somebody that's using a brand and they have the R in a circle by it, that indicates that it's registered. A registered trademark is the R in a circle. So also my suggestion is if you've got a mark that you believe is a clear mark, look at the domain at the same time and get your domain name. Everybody needs a domain for new products, and make sure that you can get a domain that's the same or similar. I will say that it's very interesting now with domain names. If you're working in the computer area and you are have a product that has to do with artificial intelligence, the .ai domain names, the high-level domain .ai for artificial intelligence, have been scooped up like crazy. It was like a get rich quick. And getting a .ai name that is a good one is very difficult these days. It's cheaper to get a .com. Also, if you are fortunate enough to have the resources and you know that there may be a market that's going to be very important for you, the trademark registration and protection procedure and law is territorial. So once you get a registration in the United States, that registration does not give you any rights in other countries. So sometimes we'll have a situation where somebody's done very, very well, but they knew that they needed to get protection in the European Union, for instance, and a clearance search had not been done in the European Union, and there's a conflict with the mark there. So all marks, all registrations are by country by country. And also there are other countries outside the US. Australia is one, Norway is one. They have very strict requirements, particularly on descriptiveness of a mark, and you may not be able to get coverage in those particular jurisdictions. So going forward with your clearance search, the U.S. Patent and Trademark Office website, uspto.gov, is a good place to start with doing your trademark searching. The website was updated last year in 2024, and it's more user-friendly. It has better functionality, and it's a much more useful tool to see what's out there. So what you can find in the US PTO.gov website is who has applied for an application or received a registration on a mark that you might be interested in seeking protection for, and also what goods and services they have sought protection for their mark. It's a very good knockout tool to see if somebody has already obtained prior rights in the US. And also for trademark clearance, the use of the mark is, and the coverage of a trademark registration is dependent on the channel of trade that the mark is used in, so that if you have a mark that you're going to be using for instance, a medical device or some type of therapeutic, and somebody has the same mark for cookies, then you're not going to be in the same channel of trade, and typically you can get protection even if the mark is identical, because the assumption is the consumers who buy cookies are not going to think that the same company is making a medical device, for instance. I will say that the clearance using the PTO website is not conclusive. Unfortunately, the best alternatives for a true clearance search are databases that you have to have a subscription to, that are private databases, and that's the kind of thing my firm does. But very often people can do a pretty good clearance search using those sources that are publicly available. Now, as far as when you're doing a clearance search, if you've chosen a mark and you found a mark that is not identical but very close, and it's used on the same goods or services you're interested in, the likelihood of confusion standard is what is used in trademark protection by the USPTO and virtually worldwide. So if there's only, a lot of people think if you just switch a few letters or change the font look or something like that, that you're going to avoid confusion. No, you really have to have something that the consumer, and it's all looked at from the eyes of the consumer. Are the consumers going to think that the source or origin of the goods and services are from the same entity? Are the marks so similar that consumers are going to be confused? And then there's also a foreign language issue, because if there is a translation that is identical, like Dove and Paloma, we're likely confused for heating products because it's the same word, but just in a different language. So you can see there's a lot of nuances here. Sunrise and sunset were found confusing for grocery stores. Also, designs and words. Sometimes you will have a prominent design, such as an eagle or other prominent designs that are used in brands in a brand logo, even though the word eagle may not be used. If you choose a word mark with the word eagle in it, and say the goods and services are very, very similar, then that can be a block for a registration also. And as I mentioned, there are subscription databases you can search globally. If you've got the money to buy a subscription to them, or know somebody who does. And then the World Intellectual Property Organization has a good free database for worldwide marks. And you can find it on wipo.org. You can just Google World Intellectual Property Organization trademark search and find it. So likelihood of confusion is kind of in the eyes of the beholder. ExxonMobil brought suit against this particular mark, FXX, that was in a totally different area of what ExxonMobil does, but they didn't like the double X's. They thought that that was too close. So that I caution people, they'll see a visual and a logo and really like the way the visual is and want to incorporate it into their brand, but that's very dangerous to do that. Unique brand names. This is I'm going to click through these. When Jeff Bezos started Amazon.com, at that time, Amazon didn't really mean anything. I think there happened to be one little bookstore somewhere in some town that had used Amazon, but nationally, Amazon didn't mean anything, and he started the brand as Amazon.com. And so my recommendation is, if you choose a brand that is not going to conjure up any connection to your goods and services, have a tagline that you use with that brand, so consumers and your customers and your potential customers will connect it. Because he started out with the Earth's biggest bookstore, and of course we now know that it's gone far beyond that, but that's the way it started. And that's a recommendation to entrepreneurs who are coming up with real creative marks. Have a tagline that goes with it. And also the tagline will also convey some of those brand value points from the one of the first slides. Okay, one of the things that I see very often is a small company, entrepreneurial company will start with one brand. And what I recommend is using the same brand for product extensions. So unfortunately, there'll be a situation. Is there a question? Sorry. Unfortunately, there are going to be, you'll come up with a little bit of a different product that's related, and there'll be another name for that product. First of all, whatever your core brand is, particularly when you're starting out, you just want to keep using that core brand, and maybe your next product is whatever your core brand name is, 2.0, or some other designation that doesn't get you away from your core brand. Because I see this all the time with people adding more and more brand names to their portfolio of new goods, and consumers don't understand this. If you can get them to remember your core brand, that's the most important thing. And it creates brand clutter, and it's just not a good way to start. And it's what I call the NASCAR effect. It's all these different brands, but what you want is to have your core brand, and then maybe differentiation with a little bit of a descriptor of your product. And now this is super important. Once you get your brands, settle on your brand, use it on everything possible. Also, brands are adjectives. They're not verbs. A lot of people make the mistake of using their brand as a noun. But for instance, on this picture, you have Heineken is beer, Starbucks is coffee, Sony is audio products, Coca-Cola's beverages. So you have to be very careful not to use your own brand as a noun and use it as an adjective. I would highly recommend that once you have your brand and you get a registration for it, to include that brand on all of your sensitive documents internally. And well, of course, any documents that are going to be going outside your company for your marketing purposes, you obviously want to have your brand, but include your brand in all internal documents as a digital header, footer, anything. And the reason is if you have any issues with your confidential documents being misused, being posted on the web in an unauthorized manner, if you have a registered trademark on those documents, it is much easier to get a takedown of unauthorized material because somebody's using your registered trademark without authorization. So much easier. And copyright is protection, IP protection for works of authorship. And your companies are also going to be doing a lot of producing a lot of good copyrighted information as well. However, the copyright protection attaches immediately upon your creation in a tangible form of whatever media you're using. You do not have to get a registration on it. And what happens is you're not going to be able to have a takedown of unauthorized posted material on the internet because you're not going to have a registration for your copyright, and the internet service provider will request a registration. But copyrighted works typically are registered when they're when you have to bring an infringement suit. It's not a requirement for protection. And this is just again on unauthorized. And here's your, I've used Success as a little makeup brand here, where you have this on your header or footer on your websites, where you've got, or on your documentation. It's very helpful with software because that seems to be what gets stolen and posted in an unauthorized manner, is to incorporate your brand in your code that you have. So enforcement on the internet is one of the focuses of why you need a trademark registration. As we've discussed, there is, as I'm sure you know, there's more and more and more unauthorized use of trademarks on the internet now. And this just goes over the little steps that you can take to get a takedown. Most of your domains have procedures where you can file copies of your trademark registration and request a takedown for unauthorized posting. The one issue here, though, is these are for the top level domains that are administered by the ICANN, which is the global administrator for most top level domains. As you, I'm sure, know, there are country level top domains. Each country has one. For instance, I have .cl for Chile. They don't have the same brand protection policies, but hopefully you won't have an issue with a country top level domain. And as I've gone through some of the other, I've gone through the sensitive information, third parties mimicking. If you you're doing well and you're out there doing well with your pitch presentations and you're making headway in the market, there are just third parties who will mimic so often. And again, I talked about the copyrighted material doesn't need to be registered, so you typically won't have a copyright registration. And also policing online dictionaries. This is another area where Wikipedia or some of the online dictionaries may pick up your brand and post some information that you want to have taken down, and having the registration really helps. the the it's interesting for high tech, for branding. A lot of people think that the best tech company with the best technology will sell itself, and that sometimes is the case. But I believe that in this competitive environment, that the company with the best technology doesn't always win. The company with the best brand and the best brand management often is the one that will beat perhaps a more superior product. And technology categories, these are created by the customers and the analysts external to the companies. So when you're picking your brand, it's really good to go in and see what technology categories and what brands are doing well in those categories. Are they the really unique brands, or are the brands that are more suggestive? And a lot of people say, well, we're going to have a whole new product category. Typically, that's not the case. They're as the reinventing the wheel is not a new product category. You have to figure out where your product is going to fit, see what the other branding is that's in that particular product category, and adjust for your branding to have yours be a standout brand, or if you want to have something that's a more suggestive brand because you think that's going to have more customer acceptance, that's the way to go. This is a very important aspect that sometimes is overlooked or either not attended to in the best manner. If you get your mark registered, which I obviously highly recommend, especially if it's a registration that incorporates a color or a logo, do not change the look when you're branding or on your website or on your product packaging. Consistency, you need to be absolutely consistent with your color and your look and your font. Consumers do get confused if there's a change. And also, I'll see clients come and they will have, well, we're going to use this color combination on this, and this color combination on another product, and this color combination on our web. And it's totally inconsistent. And the consumer is what they like. They're very dull. They like consistency. They want to see the same brand look all the time, used all the time. If you have a different people in your company or your folks that are helping you with your advertising, it's great to have a brand manual with the rules on the presentation, how you have the background colors, the spacing of the mark, just good common sense. Trademark registration in the US, you need to obtain a trademark registration as soon as possible. If you have a product or service that's going to be held up getting on the market because there's going to be delays in regulatory, marketing, or even additional product development, you can file an application for a trademark registration virtually anywhere around the world based on intent to use the mark in the future. So you can file a trademark registration in the US on one of two bases. Either the mark is currently in use or it is going to be used in the future. And also the trademark office has just redone their applications for registration. They've made them more user-friendly. and they've made them more user-friendly to non-lawyers to fill out. So I think that you might want to check that out. Why do you want to register? Well, you want third parties to know about your trademark rights. If they go on the USPTO website and you've applied for a mark or you've received a registration, they'll know about it. And many people will go there and find out, and then you'll avoid having somebody adopt a mark similar to yours. The other thing about federal registrations is they confer rights throughout the US and all their territories. A lot of people say, well, I just want to have common law rights in my mark. I don't want to spend the money on a registration. And I say, fine, but common law is very difficult to protect in the future. If somebody comes after you and gets a registration on a mark, you're going to have limited rights in that mark if you rely on common law rights, which means common law rights I'm talking about, as opposed to having a registration. It's using the mark without a registration. We've already talked about the significance for the internet. I've mentioned the options in filing, actual use of the mark or intent to use the mark in the future. And if you intend to use the mark in the future, you will have actually more than 3 years to actually use the mark. And when I say use the mark, using the mark in interstate commerce, the US is one of the most strict countries in the world on obtaining a registration, not filing, but obtaining. You actually have to have use of the mark in commerce, which means you have to have interstate sales of the goods or services to obtain a registration. And you need an accurate, this is if you're going to be filing, you need an accurate description of the goods and services. It has to be very specific. Once you file an application, you are stuck with that description. If you change your product lineup so that you have different products or different services that weren't included in an initial trademark application, you will have to file an additional application, and that's getting more expensive these days. As I mentioned, you have to have use of the mark and the goods, use of the mark in interstate commerce. Sales of the services or products must happen. So, and the specimen of use, this is something that if you're, for instance, if you want to be your own trademark registrant, you'll have to learn that you're going to have your mark used in a particular manner. Very often there's sales of goods and services over the internet. And if you do sell over the internet, you will have to have something that's equivalent of a shopping cart on your website so that people will know that they're buying a particular branded good from you. If you're selling a product, make sure you have labels on the products with the brand, exactly how you filed your application. Any kind of packaging needs to show the brand. Point of sale material. If you go to a trade show and you're selling your product and you're promoting it, make sure you've got your brand well displayed. And again, this is a little bit in the weeds, but you can't use a brochure for advertising a product to obtain a trademark registration. It actually has to be used with the goods. Brochures can be used to advertise services, and you can get a registration if you offer services for like diagnostic services, that sort of thing with your brand. But if you're actually selling a product, you've got to use the mark on the goods themselves or have a shopping cart situation. I'm just going to go over this very quickly on registering outside the US. We already mentioned the problem is that you just cannot the U.S. registration does not help you if you've got any issues with trademark coverage outside the U.S. And non-traditional, I wanted to get to this non-traditional brand protection. Color of products may be protectable, but you have to be careful. Pink was the first color mark, I believe, that the U.S. recognized, and it's the Pink Panther fiberglass insulation. It was unique. People had not sold pink insulation before, but there was a recent challenge to pink being used for a medical implant. And you're going to see the registration number here. This was from the actual lawsuit. And the Court of Appeals for the Federal Circuit decided that pink is not protectable for a medical implant because pink would be a color that would be ordinarily associated with a medical implant because it would be anatomically in sync with the human body. And so this registration for pink on a I believe it was hip replacement was challenged in court and thrown out. So, and also product packaging and containers can be protectable too. The most well-known is the Coca-Cola bottle. There has been different products such as syringes that might contain a biologic material that have a very unique color coding on it. For instance, the Tiffany blue container or packaging for jewelry, very well known, obviously. This is a really great book on strategic brand management. This is an older version that I have. You can get a newer version, but if you really want to get into your brand management, brand development, I highly recommend this book. And so my final comments on the brand selection is choose a mark that resonates with customers. Obtain the trademark registration as soon as possible to protect your brand and your other intellectual property. Maintain a brand Bible. This is very important so that everybody who is working on updating your website, preparing your packaging, preparing your slides for a pitch, you have very consistent packaging or presentation rather, but certainly consistent packaging. And I would just like to acknowledge my wonderful colleagues, Sherman Shee and Miranda Chavez, for helping with this presentation. And I believe I can turn it over to you, Jalen, and we can have some discussion if you like.
Yes. Okay. Thank you so much for that presentation. I feel like some of my nuggets, some of my takeaways from this presentation, you got to do your clearance search. You should use the US Patent and Trademark Office.gov trademark search. You can also use the free database with the World Intellectual Property Organization. I liked the talk about brand confusion with ExxonMobil and FXX. You should absolutely have a tagline if your brand is not directly related to what your product is. I think about that Amazon example, the world's largest online bookstore. Use your brand on everything possible. Your brand is an adjective. Consistent brand presentation is key. You don't want to confuse your customers. And some of the takeaways are choose a mark that resonates with your customers and maintain a brand Bible. So Meg, thank you so much. We're going to open it up to questions from our audience. and then we're gonna wrap. So anyone, like I said, you can drop those questions in the chat, or you can just unmute yourselves.
May have answered all the questions.
That's what I call a comprehensive presentation.
Jalen, I'm just gonna jump in here to offer some resources. So I know at the end of the presentation, Meg, you were talking about having a brand Bible. And so we here at the Innovation Institute have a startup clinic where we have students from the business school and the School of Liberal Arts who can do free work. They are registered as interns and they can provide free resources to companies in our ecosystem. So they have last semester, they had developed a branding guide for a few companies that would assist them in creating their social media posts and creating their website and having all their branding be identical, using very specific Pantones and very specific voice. And so we're happy to help you with that. So if you do need those resources, you can follow up with Jalen and he will get you connected. We think applications for those resources will open in February. So additionally, we have more education coming up. As you can see on the screen, we have building a no-code website and app presentation on January 29th. And very exciting, we are running a startup sprint January 31st through February 2nd. So that starts a week from Friday. So if you've ever been curious and you want to come down and learn to build a business in a weekend, we have fantastic instructors and mentors, and we're going to give away some cash prizes on Sunday night to the best new company ideas. So we'd love to see you there. And then we do have a question in the chat. I'll let you take it away, Jalen and Meg.
Yeah, Meg, can you see the question in the chat? I'm happy to read it out.
No, I can't. Can you read it for me? Sorry.
Sure thing.
I don't know.
All right. So from Artemis, hi, do you think it's worth to spend filing for a patent if it's unsure that your patent will be approved? And then is it possible for a patent to remain in the patent pending state in perpetuity?
Okay. I assume you mean trademark instead of patent, perhaps. I can answer patent as well, if you like.
Artemis, yeah, you're more than welcome to offer any clarification.
Yeah.
Hi, sorry. Yeah, I guess I would be interested in both patent and trademark if possible.
Okay. Well, let me mention this. I'm glad you brought this up. One of the things that I will say that if you do a good job of clearing your trademark, and you have a lot more control. Branding is something that is in your control. You can clear a good trademark with a high level of confidence that you will get it registered. And yes, it is, the fees just went up for trademark applications, and it's either going to be $350 or more likely $550 for the application fee these days for a trademark. But branding is something that is in the entrepreneur's control. You control the branding. Patent applications are going to typically cost more to file, although there are two ways to file a patent application. You can file a provisional patent application, which is much cheaper. And my guess is that Sharon and Jalen can help on describing the procedure, and if you have resources for helping with provisional patent applications or a utility patent application, which is the next step. That's more it's more complicated, more costly, and my view of the world is it's less predictable in what kind of patent coverage you're going to get than trademark coverage if you do your background in your trademark right. There's more predictability there. So, and understand that the trademark is only going to cover your brand, the source or origin of your product, whereas a patent is going to actually cover your invention, going to cover your discovery. Trademark registrations, once you receive a trademark registration, it is good for as long as you're using the product in commerce, as long as you're selling the goods and services. So theoretically, a trademark can be used and protected in perpetuity. Patent protection is not allowed in perpetuity. It's a limited lifetime, typically 17 years from the time of filing, but there can be extensions made. So they're both very important to entrepreneurs, both very different in their in obtaining and maintaining. So I hope that answered your question, Artemis. If not, let me know.
Yeah, looks like it did answer Artemis's question.
Okay, great.
Hi, Meg. This is Tom. I don't know if we have time for one other quick one here.
Sure.
Yeah.
Thanks so much for the presentation. I very much appreciate the information. So we're in the process of acquiring a small startup that has US and Canadian patents and trademarks and sales marks registered. And so what we're looking for now is a little bit of guidance on, and hopefully you can speak just in broad strokes to essentially the licensing of the trademarks back to the operating entity. Obviously, this is something that large multinationals do on a cross-border basis a lot. You know, you look at Ireland, you look at all the different places. But I understand that there's been a lot of updates to regulations, especially since 2019. So I'm just wondering in general if there's kind of guidance or best practice for a US brand selling a consumer products good, and then you're just kind of like looking for the best structure to license that trademark back to its own company.
Okay. If you're talking about intercompany licenses, it's my understanding that you have to, and you're talking about multinationals, there are tax considerations that have to be taken into account. And I can't speak to that. I can only bring it up because I'm not a tax lawyer, but unfortunately, you're going to have to look at the tax structure. As far as doing the licensing, the licensing is pretty straightforward. And as far as just maintaining the integrity of the trademarks, making sure when you have a license, the owner of the mark has to be responsible for the quality of the product sold under that mark. And it's very good to have to paper that up intercompany so that the company that's using the mark recognizes that there's certain levels of quality control and that they'll adhere to those levels of quality control. There's this concept called naked licensing, where one company lets another company use a mark and there's no quality control provisions between the two companies, and that can result in some problems with trademark enforcement in the future. So papering it up between the companies is not an issue, but it's my understanding that getting into the tax issues can be important there. Does that answer your question, Tom?
Yeah, it does. Thank you.
Yeah, I've never seen a licensing situation that couldn't be handled very easily up front.
Okay.
Yeah.
Well, I think that that's our time for today. Meg, if anyone wanted to get in touch with you or your office, is it possible for them to maybe send you an email
Sure.
or anything like that? Okay.
Yeah. Yeah.
Well, I will definitely, I'll definitely mention that in the follow-up email I send out. But thank you all so much for joining us. I showed Meg this when we joined the call, but I've been sitting here with my blanket all day. If you're in New Orleans, like I am, I hope you're staying safe. Hope you're staying warm. Please don't drive anywhere. It's crazy out there. But we hope to see you again soon at one of our in-person events or one of our upcoming webinars. We've got a great slate of webinars for you this spring. And here from the Tulane Innovation Institute, we'll talk to you later. Have a wonderful rest of your week.
And thanks very much, Jalen. And I saw Sam on the webinar too, so enjoyed it very much.
Of course. Thank you.
Thanks.